What updates can you provide us kind of in that development in the federal proposal to consider marijuana to go from Schedule 1 to Schedule 3? So what updates kind of are there at the federal level?
Let's talk about what's happened with federal marijuana rescheduling. And I'll back up to 2022 during the Biden administration, about midway towards second term. We saw President Biden issue a directive to HHS and the Department of Justice to review expeditiously how marijuana was scheduled under federal law. We saw HHS ultimately make a recommendation that marijuana be moved from Schedule 1, where it is and has been since the Controlled Substances Act was passed back in the 1970s, to Schedule 3. And in 2024, we saw the Department of Justice issue a proposed rule consistent with HHS's recommendation. This proposed rule itself included a 62-day public comment period. After the public comment period concluded, there was an opportunity for individuals to also request a hearing in front of the administrative law judge. The DEA decided that it was going to hold a hearing not too long after the proposed rulemaking had ended in August of 2024. And then shortly thereafter, we saw the DEA select 25 different witnesses to participate in hearings that were supposed to start at the top of 2025. But almost immediately after those witnesses were selected, there were allegations of inappropriate behavior in selecting those witnesses and communicating with those witnesses. And ultimately, the administrative law judge that was overseeing the hearing issued a stay and ordered parties to provide updates so that the determination of whether or not these things were happening could be taken directly to the DEA. This kind of brings us up to January of 2025. Since then, what we have seen, both the parties are required to give 90-day updates on the status of this determination. We've seen 3 updates to date, essentially with no status update. And since the administrative law judge has retired, of course, we know that we have a new administration, the second term of the Trump administration coming on board. And maybe 2 months ago at this point, President Trump was responding to an inquiry from a reporter where he said that his administration was looking at the reclassification of marijuana and had anticipated making a decision within the coming weeks. That decision has not come yet, but this essentially brings us up to date with where we've been in the process thus far. I do want to share a little bit of details about what this proposed rule means and looks like. Just as background, this analysis of where marijuana should be placed under the Controlled Substances Act essentially requires both HHS and the Department of Justice, or DEA, to do their own analysis to look at 8 specific scientific and medical factors. And based on those 8 factors, to make 3 specific findings. 1, what marijuana's relative abuse potential is. 2, whether or not there's currently accepted medical use. And 3, its relative safety and ability to produce physical dependence. Based on the analysis and recommendation that were made, essentially agencies, HHS has found that marijuana should be placed in Schedule 3. This would largely mean that marijuana would get a new classification. This classification would mean that the government considers marijuana to be a substance that has abuse potential that is less than Schedule 1 and Schedule 2 drugs, And most importantly, they would consider marijuana to have a currently accepted medical use. This is a term of art that, just to note, does not mean FDA approval. There's been a lot of misunderstanding and misinformation about what currently accepted medical use means, and kind of conflating it with FDA approval. But marijuana is not FDA approved, and that's part of the reason why rescheduling marijuana would create this process where we would acknowledge that marijuana has a currently accepted medical use, but medical use under state law, as well as recreational use under state law, if marijuana is moved to Schedule 3, would still be completely criminalized. I talked a little bit about the public comment period, just to kind of do a little humble brag on some organizing that I did last year. There was a 62-day public comment period, and one of the things that I did along with some of my colleagues was try and engage the public in participating in this public comment process. We actually had a record number of public comments that were submitted in response to a drug scheduling proposal. Over 43 public comments were submitted. We did our own analysis of these public comments and found that the vast majority of individuals supported descheduling or decriminalizing cannabis at the federal level. And about 40% of these comments were also talking about things like social justice and racial justice as well. We created a tool to help members of the public participate in the public comment process. And I'm proud to say that 25% of all of the comments that were submitted during that 62-day public comment period actually came from or utilized the API tool that we created. If marijuana is moved to Schedule 3, beyond getting a new classification under the CSA, there are a couple of other changes that would happen. But this is a direct a text grab from the proposed rule itself. And I think that this slide makes pretty clear in part what won't change if marijuana is moved to Schedule 3. So this comes directly from the proposed rule itself. And it says that if marijuana is moved to Schedule 3, the regulatory controls that are applicable to Schedule 3 drugs would apply, along with marijuana-specific requirements and any additional controls that might be implemented, including those that might be implemented to meet U.S. treaty obligations. I read that to say marijuana, even if it's moved to Schedule 3, is not going to be treated like every other Schedule 3 substance. There are these Schedule 3 conditions and controls that would apply, but in addition to those specific controls, the CSA has marijuana-specific requirements. And this proposed rule is essentially giving the DEA the authority to implement additional regulations that are likely to be unique to marijuana as well. The proposed rule also makes clear that the manufacture, distribution, dispensing, possession of marijuana would remain subject to applicable criminal prohibitions. This is in part because with other substances under the CSA, there are sometimes schedule-specific criminal penalties, but marijuana under the CSA is special. And so it doesn't necessarily matter if we put marijuana in Schedule 1 or Schedule 3, there are marijuana-specific criminal penalties that will apply regardless. And then even outside of the Controlled Substances Act, there are other bodies of law that are controlling in this instance, namely the Federal Food, Drug, and Cosmetic Act, which still applies and has certain restrictions and prohibitions on these activities as well. But just to reiterate, rescheduling marijuana is not going to end arrests. It's not going to release anyone from prison. It doesn't address any of the federal collateral consequences that are associated with cannabis enforcement that, of course, impacts social determinants of health. And it's not in any way going to change the legal status of state marijuana programs, regardless of whether or not they are wholly adult use programs or wholly medical programs. So I got a question, whether or not I have a sense of what special rules the administration might put on marijuana that would differ from other Schedule III substances. Yeah, I've got an inkling of at least what some of those particular restrictions might be, in part because there was a debate and contention between DOJ and HHS about what the international treaties mean. In part because outside of the Controlled Substances Act, there are also international drug control treaties that the US is party to. And these particular treaties have specific regulations and requirements that are not wholly within the CSA. And some of these treaty obligations and requirements. For example, there's quotas on the amount of cannabis that can be produced. Technically, the international treaties require all cannabis that's produced within complying with treaty country to come from and be distributed by a single source. We're in violation of that, in my opinion, already because of our state medical marijuana programs that aren't kind of managed wholly by, government entity. But I definitely think that there are going to be possession transfer restrictions that are going to be unique to marijuana. Um, the the challenge, and this is a case of first impression, in part because agencies did something that they never did before. They used a completely different test in this particular analysis to determine whether or not marijuana had currently accepted use. And every other drug scheduling decision that had been made previously, in order to determine whether or not a drug had currently accepted medical use, drugs either had to go through the FDA approval process or they had to meet this five-part test that the DEA made up that basically mirrored the FDA approval process. And proponents of cannabis reform really didn't like this five-part test for a while because they said that there was no way that cannabis would be able to pass it because cannabis itself is not FDA approved. And HHS in this particular analysis essentially said FDA approval is good, DEA's five-part test is good, but we also have this new test that we're going to use, and it should be considered good as well. And part of what this new test relied on is essentially plainly looking at what's happening across the states and asking, are people who are licensed healthcare practitioners utilizing this in their practice at the state level? It's a simplified version, but they essentially created a whole new test for currently accepted medical use. And because of this new test, marijuana is in a would be in a unique situation than any other drug that has gone through the scheduling process because it would have kind of escaped this previous limitation of only being able to meet the standard through FDA approval or basically FDA approval light. But if you all are interested, if and when the actual final rule comes out, the first thing that I would do a keyword search for handling. There should be a section of the proposed rule called handling requirements. This is where the final rule should specify what specific restrictions are being placed on marijuana as a Schedule III drug.
Awesome. Thanks so much for that, Kat. And had a second question you may have seen come in. How would rescheduling impact campuses in their need to comply with the Drug-Free Schools and Communities Act, which I think Nan is referring to here, is that right now they are, cannabis-free zones because of that compliance with Drug Free Schools and Communities Act. So how would rescheduling impact campuses, excuse me, need to comply with federal policy?
Yeah, that you're still going to have to comply with federal policy, and federal policy is still going to consider cannabis use to be illegal under this framework. Um, there isn't a mechanism for people to kind of lawfully both possess and use cannabis under federal law under a rescheduling situation. And so I do think that this is where folks in higher education, campus professionals, my recommendation and kind of concern in this is that there's been so much misinformation. I've seen like Forbes put out articles that suggest that it's going to legalize medical marijuana or you know, protect or create some type of rights. I would hate for folks to think that they've gotten some rights under this rescheduling process. They do not have those types of rights. I don't want your students to go out and assume that they've got new rights that they don't have. And so I know everybody's got their educational resources and informational resources. I think it would be completely worthwhile to update those resources once a decision comes out, even if it's just to clarify that in these circumstances, there is no change to the policy. But I think that we in this space are going to be fighting up against, in part, an industry that is cheerleading this in part to try and make it seem like it is more than it is. And part of the reason why the cannabis industry, is so keen on trying to champion rescheduling is because one of the things that actually will change if marijuana is moved to Schedule 3 is that the cannabis businesses would get a tax deduction for the first time. There's a specific IRS code called 280E that prevents businesses from making normal business deductions if they're trafficking in Schedule 1 or Schedule 2 drugs. And so if marijuana were moved to Schedule 3, this particular tax penalty would no longer apply. And essentially, the industry would get tax parity with every other cannabis business. Now, I don't think that the cannabis industry should be treated differently in terms of its tax deductions, but I don't think that that's a reason to lie or overstate what the significance is of this particular policy. So campuses should still be cannabis free. With this rescheduling decision, well, I'm sure we'll shift into talking about some legislation as well. We have a little bit more flexibility and room to innovate through Congress, but rescheduling is not going to change whether or not your campus is cannabis free. That will stay the same.
Absolutely, Kat. And before getting in to the question around potential legislation and movement on that front, did have another question come in is with rescheduling, would there be an opportunity for potential FDA approval for any type of like medicinal things that include cannabis products?
So what I'll say is no more opportunity than exists today. There are already cannabis derived FDA approved drugs like Marinol, things that are isolating cannabinoids like THC and CBD. But we're not seeing, in part because the FDA approval process wasn't made for whole plant drug development. Um, so there's nothing stopping a pharmaceutical company from taking, an isolate or cannabinoid for a particular treatment through the FDA approval process now. And that process remains unchanged. It's like rescheduling and the process is over here, FDA approval and the process is over here. They're not impacting one another. And so just like today, if you had Marinol, if you're a student or someone else had a prescription for an FDA-approved drug, Marinol, that would be legal on campus today. It would be legal on campus tomorrow. But until we see FDA approval of specific products, and you got to think about it, like in Ohio, There are hundreds, thousands of different cannabis products that exist on the shelves from different brands. It's only the specific product that receives FDA approval that is then lawful for someone who is using that product pursuant to a prescription. And so all these products that exist today in the medical market and the adult use market, um, based on current federal law, should still not be allowed on campus.
Awesome. Thank you so much for that, Kat. There's just so much I think going on there, but I think it's very, very useful, and I know it would be for campus professionals as well. And I know we're slowly running out of time, which is sad. But I do want to transition to potential legislation. So, what updates or insight do you have on potential legislation or things that are moving and shaking with key people in the legislature in the current 119th version?
Yeah, so I'll say that Congress is going through a lot right now, right? They're not in session, but I monitor this area very closely, working in communication with members of the Congressional Cannabis Caucus that exists at the federal level. There are two Democrats, two Republicans who are chairing that body. And um, to be frank, I think that cannabis reform in this particular Congress is viewed as unlikely, unless it is kind of narrowly focused on specific sets of issues like veterans and banking and research. Um, I think that that is to kind of the detriment of the reform space. There are lots of different issues that need to be addressed by federal law. The gap between state and federal law continues to be exacerbated by the day. And there has been some standalone cannabis legislation that has been introduced in this Congress, in the 119th Congress. So I'll spend a little bit of time walking through those bills. And then I do want to talk a little bit about two bills, one that's been introduced this Congress and one that hasn't yet, that I think should be on you all's radar as professionals in the higher education space. So, one bill, this is the only bill that's been introduced in this Congress thus far that would actually deschedule cannabis, decriminalize cannabis, is the MORE Act. It would fully decriminalize cannabis and provide for reinvestment in communities impacted by the war on drugs. It would also ensure that there's expungement of cannabis offenses. This is considered by the Drug Policy Alliance to kind of be our North Star at the moment. It not only deschedules cannabis, but includes all of these other provisions that we think are key to ensuring that we're prioritizing public health and health equity. Um, there is another bill called States 2.0. This bill would essentially create an exception under the CSA for activity that happens under the state that is state compliant. Um, there was a Department of Justice memo that had come out several years ago known as the Cole memo that essentially articulated the uh, Department of Justice's enforcement priorities and essentially said if states aren't engaging in these 8 things or monitoring these 8 things, then we're not going to enforce against them. This particular bill, in a sense, was trying to kind of codify that memo that is no longer in effect, but it would not decriminalize cannabis per se. I think that even under a state's 2.0 situation, institutions of higher education and college campuses are still going to be in a bit of a gray area. There have been a number of bills that have focused on veterans access specifically. There are current policies that prevent VA doctors from even recommending or making referrals, completing paperwork so that veterans can access medical cannabis. Excuse me. And there have been a number of bills that have been introduced to address that. There's real tension in conflict. Some members of the various parties um, on cannabis, and I say this because on one hand, we had a bill called the Marijuana 1 to 3 Act that would essentially have accomplished what rescheduling is accomplishing with moving marijuana to Schedule 3. And then we saw essentially opposing legislation that would make it so that like rescheduling wouldn't happen. There's been appropriations language introduced by certain policymakers to try and prevent rescheduling from happening. And then a bill like Marijuana 1 to 3 that would enact rescheduling. And so there's definitely a conflict between federal policymakers on what to do. And I think that that's also what causes kind of this sustained inaction. There are bills that have focused on things like direct to consumer sales that are kind of preconditioned on interstate commerce. So folks kind of thinking down the line, these aren't going to happen anytime soon. The issue that I think is most likely already on your table and going to continue to cause headaches for higher education professionals is hemp related stuff. So, hemp and cannabis are technically the same plant, but with the Farm Bill that was passed and signed into law in 2018, there was an exception under the CSA essentially for cannabis that had less than 0.03% THC. And what we've seen since then is proliferation of intoxicating cannabinoid products, hemp-derived intoxicants, largely because folks are able to take that 0.03% THC product, isolate it through various extraction methods, and then create things that are intoxicating. And so we have a situation in which we have these parallel markets. Cannabis can be criminalized in certain jurisdictions or heavily regulated in others. And hemp is largely unregulated, has the same public health challenges, and we were not paying as close of attention to it. And it can be the same thing that causes folks to, not pass drug testing or just experience personal consumption challenges. So people need the same types of resources, public health resources, harm reduction resources that would be necessary for cannabis, I think are also applicable for hemp. These two bills, the Prepare Act and the Evidence-Based Drug Policy Act, are bills that I think probably outside of like veterans, banking, have the most likely shot of moving in this Congress, in part because they don't do the most. The Prepare Act essentially would require the federal government to establish a commission to prepare for a federal cannabis regulatory framework. And essentially, most of the commission members would be federal agency heads, but there are also seats for non-government officials, and they will be responsible for putting together recommendations on what this framework could look like. This is important for us to kind of figure out what this framework looks like. As someone who's a local regulator in California for several years, and now seen 50 different versions of what state regulation can look like. There's an increasing desire amongst states for standardization, but states have their own interests. And for better or for worse, because of commercialization, there are now economic interests that states have that are tied to these programs that aren't always directly tied to public health. So working closely with different stakeholders to figure out what that would look like, who should be the appropriate regulatory agency, what should the interface be between, for example, a Department of Education at the federal level and colleges and universities, how do we address things like the Drug-Free School and Communities Act post prohibition framework. I think that these are all important topics that we want to figure out before we need to. There's another bill. There's a bill that we worked closely to try and introduce that would remove an existing provision of the CSA that our Office of National Drug Control Policy is not even allowed to study the impacts of legalization. And they're also required by law to oppose the legalization of any Schedule I substance. And this bill would essentially remove those provisions so that they actually could study the public policy impacts of legalization, and wouldn't be statutorily required to oppose the legalization of any substance, any Schedule I substance. I'll pause there to see if there are any thoughts, questions about what's happening in the 119th Congress or different federal legislative priorities. And I'll just add, there is a bill called it's like the Higher Education Research Act. It was carried by Rep. Dina Titus. This is a bill that would it wasn't introduced this Congress, it was introduced last Congress. It would allocate funding for universities that were trying to do cannabis-related research. It would essentially create policies so that universities could establish their own policy. I name this because folks are already talking about this. Folks are already thinking about this. I don't think it's so far-fetched when the politics are suggesting states' rights, that we may be in a situation where it's a states' rights situation, and then colleges and universities are responsible for putting together their own cannabis policies. And so, yeah, if you all aren't already lobbying through some type of effort to ensure that you all are getting the types of resources and support that this system that will be built about you, and about your students is actually going to work for your students, let's have a conversation.
Awesome. I need to hand it back over to Anthony, but I want to give you 30 seconds. What resources are available from the Drug Policy Alliance where we can stay kind of plugged in on this issue and like find some of these resources?
Yeah, absolutely. And I'll drop it in the chat, but you all can reach out to me at cpacker@drugpolicy.org. I would love to continue to work with this network of professionals. Our website is drugpolicy.org. You can sign up for our listserv and get updates on federal legislation and everything that we're doing to track what's happening at the executive level as well. I talk about these things all day, every day, so I'm always excited to connect with other folks. And so I'm also remiss that we ran out of time, but would be happy to come back and spend time with you all.
Awesome. Well, Kat, thank you so very much. I know I'm similar to many of the other people in the audience. Vicarious notes, this is just a topic that we're all dealing with. And so very, very much appreciative of your time and expertise.